Hello everyone, I'm Alex Grant and welcome to Immigration Update Desk. Over the past few days, a surge of headlines and policy chatter out of Washington has left many U.S. citizens and immigrants uneasy about what dual citizenship means going forward, because for years holding two nationalities was largely a quiet, uncontroversial fact of life for millions. Parents raising binational kids, Americans living abroad for work, naturalized citizens keeping a connection to their country of birth. But as late 2025 rolled into 2026, new guidance, internal reviews, and security-focused discussions began to tighten attention on when and how dual nationality intersects with immigration benefits, sponsorship duties, federal employment, and even the basic logistics of traveling with more than one passport. That shift from quiet tolerance to closer oversight is why this briefing matters, not to amplify rumors or stoke fear, but to translate what agencies have actually said, how officers are applying existing rules more strictly, who is most likely to feel the effects first, and what practical steps you can take right now so your status, travel plans, and family immigration goals remain secure. The renewed focus on dual citizenship sits within a broader national security and enforcement review. DHS, the State Department, and other agencies have signaled through policy memos, staff training, and updated internal FAQs that they are reassessing how multiple nationality interacts with security clearances, overseas voting or political participation, long stays abroad by naturalized citizens, affidavit of support sponsorship for relatives, and the use of foreign passports at U.S. borders. To avoid confusion, remember the baseline. The United States does not have a statute that outright bans dual citizenship, and the Supreme Court has long recognized that citizenship cannot be stripped arbitrarily. But the government has also never fully codified dual nationality as a preferred norm, which leaves a gray space where agencies can legitimately ask more questions, demand clearer disclosures, and enforce long-standing rules that many people have treated casually for years. One of the clearest near-term changes is in disclosure. U.S. citizens who hold another nationality are facing more detailed questionnaires in several contexts: passport renewals and first-time applications that ask about other citizenships and passports currently held, family-based immigrant sponsorships that probe domicile and tax compliance more carefully, trusted traveler and security-sensitive programs that require explicit attestation of every foreign passport you possess, and certain immigration interviews where officers compare prior entries, ESTA or visa records, and passport usage to ensure the narrative is consistent. None of that makes dual citizenship illegal, but it does mean the era of don't ask, don't tell is over. If you possess a foreign passport, agencies want it disclosed in the appropriate form, and they want to see that its use does not conflict with U.S. law, your oath, or program rules. Naturalized citizens understandably ask whether this climate threatens their status. The short answer is no for the vast majority, with an important caveat. Citizenship obtained lawfully and honestly is extremely durable, but denaturalization can be pursued in narrow, serious circumstances, typically for fraud or willful misrepresentation that was material to obtaining citizenship, or for certain post-naturalization acts tightly defined in law. So what these reviews really do is prompt officers to recheck whether the original naturalization record and subsequent conduct line up. That is why long, mostly uninterrupted residence abroad, right after naturalization, service in a foreign military with an oath of allegiance, or senior roles in foreign governments, can trigger questions about whether the person understood and complied with the oath of allegiance at the time of naturalization. Those situations are not automatic violations, but they move a file into a higher scrutiny lane. The best protection is transparency and documentation, Keep copies of your naturalization file. Be ready to explain any long stays abroad, employment contracts, caregiving, postings. And if you served in a foreign force or government, discuss the facts with competent counsel so you can disclose accurately in any U.S. form that asks. Travel is where dual nationals feel the change most quickly, because the rule that U.S. citizens must enter and leave the United States on a U.S. passport is not new, but is now being enforced more consistently. Officers at ports of entry have reported more cases of travelers being questioned because airline systems or advanced passenger records show a foreign passport was used to check in while a U.S. passport appears at the border, or because an ESTA record exists under a foreign passport for someone who is in fact a U.S. citizen. The fix is simple but important. When flying to or from the United States, book and present your U.S. passport for the U.S. leg, and carry your other passport for the foreign country's entry-exit formalities if that country requires it. But do not attempt to enter or leave the U.S. on the foreign passport. If your U.S. passport has expired, renew it before travel. If your name order or spelling differs across passports, carry proof of the linkage, such as a name change order, marriage certificate, or a prior passport, so officers can reconcile records quickly. If you have children with 2 nationalities, make sure each child's U.S. passport is valid and used for U.S. entry, even if the other country requires its own passport for exit or entry. Dual nationality also intersects with immigration sponsorship in tangible ways. U.S. citizens petitioning spouses, parents, or children are being asked more pointed questions about U.S. domicile and continued tax obligations when their day-to-day life is clearly abroad. This is not new law. Sponsors always had to show they either maintain domicile in the United States or will reestablish it by the time the immigrant is admitted. But adjudicators are applying the standard more strictly, which means sponsors who primarily live overseas should gather concrete proof of plans to return. Job offers, leases, school enrollments, shipping and relocation records, and stay current on U.S. tax filings because failure to file can complicate the affidavit of support. Remember that the I-864 is a binding contract, so officers want to see not only that income meets the current poverty guidelines for the correct household size, but also that the sponsor has real ties to the U.S. that make enforcement plausible if necessary. Joint sponsors remain an option, but they don't cure domicile. Petitioners still must show their own domestic tie or plan. Security clearances and certain federal roles continue to apply a trust but verify philosophy that treats dual citizenship as a factor to be mitigated rather than a disqualifier. Agencies have reiterated that applicants must disclose every foreign citizenship and passport and provide details about foreign contacts, property, financial accounts, and travel. Mitigation often includes demonstrating strong U.S. ties, a history of lawful conduct, and, for some programs, relinquishing or not using the foreign passport. Failing to disclose can be worse than the fact of dual nationality itself. Non-disclosure can lead to clearance denial, job termination, or debarment from sensitive contracts even for otherwise qualified U.S. citizens. If you work in or plan to enter a clearance-bearing field, read the adjudicative guidelines carefully. Keep a running list of foreign trips and contacts and be proactive about disclosure. For Americans living abroad, dual citizenship and enforcement touch on tax, voting, and residency declarations. The U.S. taxes its citizens on worldwide income, and while credits and exclusions can reduce or eliminate double taxation, failing to file returns or required disclosures, like the FBAR for certain foreign accounts or Form 8938 under FATCA thresholds, can complicate passport renewals or trigger uncomfortable questions when sponsoring relatives. Likewise, voting in foreign elections is not per se unlawful for U.S. citizens. But if a foreign election requires an oath of allegiance or your participation creates a record that suggests you claim rights reserved to nationals alone, you should be prepared to explain how your participation fits both countries' laws. When you renew a passport from abroad, consular staff may ask about your residence and tax status. Have short, factual answers and supporting documents so the process stays routine. None of this is a mass revocation campaign or a new law banning dual citizenship. It is a tightening of enforcement around rules that have existed for decades, emphasizing clarity, documentation, and accountability in contexts that touch national security, immigration benefits, and federal oversight. Most law-abiding dual citizens will experience little more than longer forms and a few extra questions, but those with complex histories, inconsistent records, or long periods of non-compliance may face deeper review. As 2026 begins, the smartest move is a short personal audit. List every passport you hold. Check that your U.S. passport is valid and that you use it to enter and leave the U.S. Make sure your tax filings are up to date or get onto a compliance pathway. Inventory your foreign military, political, or government service, and gather documents that explain context. If you sponsor family, strengthen your domicile and financial evidence now. IRS tax transcripts, employer letters, bank statements, and proof of housing, and ensure your I-864 math is correct. If you are in or pursuing a clearance-related career, prepare full disclosures and keep a travel log. If you frequently cross borders, standardize your name format across documents and carry proof of name changes to avoid mismatches at airline check-in and immigration kiosks. Because misinformation thrives in uncertainty, here are common myths and the facts that replace them without drama. Myth 1 says, dual citizenship is now illegal. But in reality, the U.S. still permits dual nationality as a matter of tolerated practice. Myth 2 says naturalized citizens are losing citizenship for traveling, when the real risk is not travel itself, but the combination of misrepresentation, certain foreign allegiances, or living facts that directly contradict the oath, things adjudicated on evidence, not rumor. Myth 3 says you can choose whichever passport you want at the U.S. border, but the law is clear. U.S. citizens must enter and depart on a U.S. passport. Myth 4 says if I live abroad, I don't need to file U.S. taxes, whereas citizens must file based on income thresholds, even if credits later wipe out the bill. Myth 5 says a joint sponsor makes domicile irrelevant. But a joint sponsor does not cure the petitioner's obligation to show U.S. domicile for family cases. To make this concrete, imagine a few typical situations and the better choices in each. A naturalized U.S. citizen working on a 5-year overseas contract keeps U.S. tax filings current, maintains a stateside mailing address, renews their U.S. driver's license when allowed, and collects documents that show continued U.S. ties. When sponsoring a spouse, they add a signed job offer showing they will return, a lease starting next quarter, and proof of bank transfers to a U.S. account. Altogether, a strong domicile story. A binational traveler keeps both passports valid, uses the U.S. one for U.S. legs and the foreign one for the other country's entry rules, and carries a simple letter from their employer, plus recent pay stubs, in case officers ask about ties. A dual national in a defense-adjacent career discloses foreign contacts and passports up front, stops using the foreign passport, and seeks written guidance from security officers about whether formal relinquishment is advisable. A U.S. citizen sponsoring a parent while living abroad lines up a U.S. co-sponsor but also documents their own return plan, job offer, housing, school plans for children, so the file satisfies both financial sufficiency and domicile. If you worry your situation might be complex, long absences, foreign military service, inconsistencies in earlier forms, Seek a tailored legal consult. A 1-hour session that helps you produce a clean, consistent record is almost always cheaper than the months lost to an avoidable request for evidence or a misinterpretation at the border. When you complete government forms that ask about other citizenships or passports, answer accurately, even if the truth triggers extra questions. Non-disclosure is the fastest way to turn a small issue into a large one. If you recently naturalized and will be assigned abroad by a U.S. employer, ask whether preserving continuous residence for future naturalization benefits for qualifying employment is relevant to your family members and whether any forms apply. If you are a dual national parent of U.S. citizen children born abroad, confirm that their U.S. citizenship documentation, consular report of birth abroad, and U.S. passport is accurate now, not when you're rushing to travel. Travel planning in 2026 benefits from redundancy and good documentation. Carry a paper copy of your U.S. passport data page and a digital backup in a secure cloud. Keep a list of emergency contacts memorized in case your phone is unavailable in secondary inspection. Know the location of the nearest U.S. embassy or consulate where you travel, and avoid leaving the U.S. when time-sensitive filings or interviews are due. If you anticipate extended trips, apply for a U.S. passport renewal early to avoid last-minute constraints. If you must show vaccination or other travel health records, store a printable copy alongside your passport. If your name includes diacritics or multiple transliterations, standardize one spelling for U.S. documentation and list the alternate in the Other Names Used section where forms ask. For Americans living abroad long-term, keep your voter registration details accurate and understand local laws regarding foreign participation in politics because U.S. officers may ask how you engage. If your foreign country imposes military or civic obligations on citizens, consult both countries' laws to avoid conflicts with U.S. obligations. For financial compliance, gather bank statements, interest, dividend summaries, and any forms your foreign bank issues for U.S. reporting. Building a tidy packet each year makes tax season saner and reduces the risk that a passport renewal invites extra questions. If you support or sponsor family, expect 2026 adjudications to ask for clearer evidence that you can and will support the immigrant without reliance on restricted benefits. Beyond the I-864 math, provide evidence that paints a realistic picture of stability, recent pay history, letters on employer letterhead, a lease or mortgage, utility bills, and, if you've been abroad, documents that map your return schedule. If you rely on a joint sponsor, ensure they meet income thresholds with IRS transcripts and understand the contractual nature of sponsorship. Officers increasingly contact joint sponsors to verify awareness. Finally, keep perspective. This is not the first time the U.S. has tightened oversight in response to global events, and historically such cycles produce extra paperwork and slower processing before settling into a new normal. The way through is preparation and steady compliance, not panic. Dual citizenship remains a recognized reality of modern life, but the price of that convenience is clearer disclosure and cleaner records. Immigration Update Desk will continue to read the source documents, compare them with what travelers, sponsors, and officers report on the ground, and explain what each change means in practical terms. What to present at the border, what to upload to the NVC, what to say on a passport renewal, and when to seek individualized legal advice. If this helped you cut through the noise, subscribe and tap the bell so you don't miss timely updates. If you have a scenario you want us to address, share enough detail in the comments to keep it useful but protect your privacy. And remember that while tone has shifted from quiet tolerance to closer oversight, most dual citizens who follow the rules, use the U.S. passport for U.S. travel, disclose other citizenships when asked, file taxes, document domicile when sponsoring, will move through 2026 with little more than extra questions and slightly slower timelines. Be the person whose file answers those questions before they're asked, and you will convert scrutiny into smooth approvals.